In the present case, while the notice is termed as an intimation of tax, 73(1) में 74(1) में दोनों में intimation of tax पहले देनी है by way of a letter or whatever. A show cause notice follows after this. If the assessee fails to pay tax interest in 73, tax interest 15% penalty in 74(1), then show cause notice comes. वो कहते हैं in the present case, while the notice is termed as an intimation of tax ascertained as being payable under 74(5), but the intimation issued in the form of DRC-01. DRC-01 is in the form of show cause notice, which is issued on section 74 of the Act in accordance with 142 so and so. At the stage of intimation so and so, DRC-01 which is applicable. Next, we can leave this routine. Therefore, while issuing an intimation, the proper officer in the notice could not have said that the failure on the part of notary may entail the consequences of recovery of the entire amount with penalty and interest. ये उसमें लिखा था. वो कहते हैं इसका मैं क्या जवाब दूं? वो तो पहले इश्यू प्री जज कि तू कुछ भी लैंड में तेरे से टैक्स रिकवर करना है, इंटरेस्ट रिकवर करना है, पेनल्टी रिकवर करनी है. The department needs to correct itself not only as regards their understanding of the entire procedure, but even the contents of the forms. The intention of the proper officer was to give an intimation in accordance with subsection 5 of 74, and therefore the intimation should have been in the form of DRC-01A and not DRC-01. Why we put up this judgment? Number one, when you get these kind of intimations on that, you have to see whether it is as per the form. राधा कृष्णन ने क्या बोला था 74 को इंटरप्रेट करते हुए? आपको not only substantive law but also the procedures have to be duly followed. So if the procedure 01A, you cannot issue DRC-01. The forms are prescribed for the only this purpose कि ऑनलाइन सारी इंफॉर्मेशन आपके पास अवेलेबल हो. Therefore that you cannot do it. तो अब assessee स्मार्ट था, maybe wanted more time or whatever, because the time pursued in high court can be excluded. उसने कहा जी ये बॉर्डर है और हमारे जितने भी नोटिस आते हैं उनमें लिखा होता है अगर ये नहीं करोगे तो अरेस्ट कर लेंगे, जेल में डाल देंगे. ये आंसर इज नो. He has a right of giving a reply to you. Only then you pass the order. Next, please. There is a vast difference between 142(1A) rule and rules 1A, which amendment हुआ है. From now onwards, if the department deems fit to issue any intimation of tax ascertained as being payable under 5 of 74, it shall issue a notice in 1A, and in such a notice of intimation, the proper officer shall not threaten the dealer if it fails to comply with the intimation. Department shall proceed to recover the tax. And no threats can be used. Now, there is a tendency of most of us agreeing that only jurisdictional high courts or judgment are binding. There is a judgment by Supreme Court, you can note down, Kusum Ingots Limited versus Union of India. Kusum Ingots versus Union of India, where the Supreme Court has held that if a central act is interpreted by any high court, the law laid down by any high court shall be binding on other high courts also, unless the jurisdictional high court has a contrary view. Right? So once this high court has held imputed tax in this is quashed and satisfied, this becomes a law. कि आपको 42(1) कैपिटल ए का प्रोसीजर आपको फॉलो करना है, पहले 1A में करना है, उसके बाद आप 1 में जाइए, उससे पहले नहीं. उसका रीजन है कि जब आप पहले ही इश्यू कर देंगे तो पेनल्टी विल बी अट्रैक्टेड ऑटोमेटिकली. जब आप इनिशियल नोटिस इश्यू करते हैं 73 में पेनल्टी नहीं लगती, 74 में पेनल्टी 15% है. If you fail to deposit that, or fail to honor this intimation of tax, then the show cause notice comes and the higher penalty comes. Tax interest shall continue. So it will defeat the whole purpose if right at the intimation of tax stage you start giving threats. हम ये कर देंगे, वो कर देंगे, बिजली करोगे. This is not allowed. Next, please. Yeah, I think this is all today. Tomorrow we will touch. Tomorrow will be last session of this 50 hours training. Tomorrow we shall complete 50 hours. I hope so. Same timing. We'll be touching section 67, 68, 69. Right? We have done the theory. Tomorrow we'll do the practical part. And in the process, we'll also be doing some 3 or 4 judgments on e-way bills. Only 3, 4. I'm not a very good at e-way bills generations. but there are some judgments I read that they are very important. This PPT is available with you. जितना पढ़ोगे उतना सीखोगे. And this document, I again repeat, cannot be shared with your friends. This is my work. I don't want it to be shared. I don't share with any other group. Not that they will value or it's a very invaluable thing. Anybody can make it. But since made for our group, we will keep it to ourselves. I'm not very happy sharing this knowledge with others. But they will read, they won't understand anything. They're not a part of this discussion. So in any case, it should not be given. Now, if you go back to section 7, 67 के लिए section 7 आपको दोबारा पढ़ना होगा. What is supply? If you read section 67(1), I'll tell you the important interpretation of the section 67(1). Where the proper officer, who's the proper officer? Who has the sanction to conduct a raid, not 291. Who has INS 01 signed by an officer not below the rank of Joint Commissioner. He is the proper officer for section 67. Has reason to believe. Now here is not to form the opinion. Like section 83, Commissioner must form the opinion. Here the legislature used the phrase has reason to believe. And that reason could be very subjective. But they also must be fairly tangible before any sanction is given. But the justification of reason to believe is not to be questioned at this stage. Courts don't bother. That's a reason to believe. So reason to believe is much wider than forming an opinion. Opinion is always based on tangible law and tangible material. Reason to believe is, it's very subjective. It may not be justified. But he has put some reason to believe on record. For example, he said, "जी मैंने Mr. Verma का investigation किया था. Mr. Verma has been dealing with Mr. ABC, who is a total bogus dealer." This is a reason to believe that Mr. Verma may also be indulging into nefarious and tax evading activities. Or he says, कि जी मैंने Mr. Verma का account देखा है, इनका तो इनपुट टैक्स क्रेडिट का भरमार है, टैक्स उनका होता ही नहीं. ये जब भी कहते हैं एग्जाम्प्ट गुड बेचते हैं, खरीदते हैं टैक्सेबल गुड्स हैं, बेचते हैं एग्जाम्प्ट गुड्स हैं. ये कहां से लाते हैं? दिस इज रीजन टू बिलीव. देयर कुड बी थर्ड रीजन कि जी हमने जीएसटी में देखा है इनके हर चीज में लिटिगेशन चल रहा है, रिफंड मांगते हैं, गलत है, इनपुट टैक्स गलत है. So anything that gets connected with GST law, where this proper officer, not below the rank of Joint Commissioner, who sanctions him, he has reason to believe कि इसमें कुछ गड़बड़ है. Now he has to put up a report to Joint Commissioner कि जी इस सुशील वर्मा का ये चिट्ठा है हमारे हिसाब से. Therefore, we need to invoke section 67. Therefore, please give me authorization. INS 01 form. Whenever a person comes to your business premises and wants to conduct a search, your client has a right to see the authorization. Authorization में अगर नाम अभिषेक राजाराम का लिखा है, nobody else can search. नाम लिखे जाते हैं. जो 3, 4, 5, 10 बंदे जो भी हैं, उन बंदों को उसमें नाम लिखे जाते हैं कि these people are authorized. If they are authorized on for 1st January, they cannot go on 2nd January. They have to have a 2nd January search warrant again. Or the form can say 1st January to 3rd January. They can go all 3 days. They can go any one of these days between 1, 2nd, 3rd. So you have a right. So the proper officer in terms of section 67 is totally different than we understand 291. Here he has to be authorized by a person not below the rank of Joint Commissioner. Go to section 2. Section 2 in the beginning. In this act, unless the context otherwise requires. This phrase is very important to read any law, whatever law you read. Are we know 291 proper officer definition? Now this context changes the definition of proper officer. A proper officer for the purpose section 67 is one who is authorized by person not below the rank of Joint Commissioner. Right? So this is the opening phrase is in all the acts, whatever acts in the world are made. In this act, unless the context otherwise provides. So here contextual difference comes and the proper officer will not be anybody authorized by commissioner. The form has to be given to him by a person signed, not by the person below the rank of joint commissioner. Additional commissioner can do. Any higher officer can do. Assistant commissioner cannot do. Deputy commissioner cannot do. Right? Again, you say a taxable person. So rate can be happen on anybody. Who's taxable person? Go over to section 2. So there is no word registered person. So if they raid my office in Indra Prakash building, they can raid, provided they say I'm a taxable person. Now this taxable person, at what stage they have to prove? Bolo Vakil Sahab. How do they prove that you are a taxable person?
So if they have any evidence that either you are crossing the threshold or you have done any kind of an
are they supposed to show me?
They should have reasons to believe.
Okay.
And if they have reasons to believe, they can either come with their own.
Now supposing he's right. Supposing they come and raid your office, you say, sir, we deal only in Schedule 1 goods. हम और कोई काम नहीं करते. Therefore, we are not taxable. At that time, you can question them. Do you have information against this with you? Give them a letter. Let them raid. Give them a letter. You questioned it. Why I am dealing only Schedule 1 goods? मेरा कोई काम ही नहीं है. Or I am a 100% export unit. But they still remain taxable because the exports are not tax free. They are not part of Schedule 1. They are zero rated by your Section 16 IGST Act. They are not tax free. Exports are not tax free. Exports are taxable. Only you get ITC refund. That's all. So a taxable person in this context will change. Has suppressed any transaction relating to supply of goods or services or both, or the stock of goods in hand, or has claimed input as credit in excess of his entitlement in this act, or has indulged in contravention. So जो भी आप GST में लिखा है वो सारा इसमें कवर है. And to do all this, what he has to do? He has only reason to believe. He doesn't require a tangible evidence to prove at the point of search कि आपने ये किया है. Reason to believe us. So therefore, this search becomes open-ended. He can search your house, he can search your documents, he can search your factories, he can make you stay there, he can take up your redefinition of document, section 2. There is a material change in the definition of document in GST law. Pardon?
Written or printed records of any sort and electronic records.
So all your computers, email are covered by definition of document. Your mobile phones are a part of document. Therefore, they can seize everything and take away. You cannot say computer you can't have, they can. Because the word document includes your e-records and printed records. Right? Because they are authorized by law. We are concerned with ये है अगर ये एंट्री नहीं होती तो वहां एक इंटरप्रिटेशन बनती थी. उन्होंने इंटरप्रिटेशन को जीएसटी में खत्म कर दिया. ये पहले सुप्रीम कोर्ट की जजमेंट्स हैं कि ये चीजें एविडेंस है या नहीं. नाउ देयर इज नो इंटरप्रिटेशन की एविडेंस है या नहीं. बी एनी पर्सन एंगेज्ड, ये तो पहला है जो टैक्सेबल पर्सन है, हु सप्लाइंग गुड्स और सर्विसेज और बोथ. द वर्ड इज और आफ्टर ए. Now you come to B. Any person. Now A says a taxable person, B says any person. So go back to definition of person, section 2. This inclusive definition. ये person में any person, ये कोई भी किसी भी कैटेगरी का आदमी हो, any person engaged in the business of transporting goods, or an owner or operator of a warehouse or a godown or any other place. What is the difference between godown and a warehouse? सारे चार्टर्ड अकाउंटेंट्स को बताओ मेरे को क्या डिफरेंस होता है. क्या होता है जी इलाज बताइए. राविंद्र को बोला था यू आर मोस्ट क्वालिफाइड. Warehouse can store goods belonging to various parties. godown is specific to a unit. That's the difference between warehouse and godown. जितने कोल्ड स्टोरेज हैं ये सारे वेयर हाउसेज हैं, तो काफी लोगों का माल रखा जाता है वहां पर अगेंस्ट पर्टिकुलर स्लिप्स. दैट इज व्हाई द लेजिस्लेचर यूजेस टू वर्ड्स गोडाउन और वेयर हाउस. You must make notes on these differences. This makes you a good lawyer. Work or no work is a different matter, but you become a good lawyer to note down these concepts. इनका फर्क क्या होता है? कॉमन पाले में तो कोई फर्क नहीं है, वहां भी माल रखा है, वहां भी माल रखा है, but warehouse goes on a different tangent. Or any place is keeping goods which have escaped payment of tax or kept his accounts or goods in such manner as is likely to cause evasion of tax payable under this act. So B is not linked with taxability of a person. A is a taxable person. They have to prove. If you are not likely to taxable person, put an objection on record. यदि मैं तो शुरू मांग में गुड्स करता हूं, मेरे को लेना देना नहीं है. Let them rate, doesn't matter. But you say I'm not a taxable person, I'm not registered or required to be registered. So I don't have to pay tax at all. और मैं कोई ऐसा सामान भी नहीं खरीदता जहां मेरे को टैक्स देना है. B कहता है एनी पर्सन, गोडाउन हो, वेयर हाउस हो, को ट्रांसपोर्ट हो, कोई भी हो. But the last phrase is evasion of tax. So the concerned proper officer has to have reason to believe that if he wants to invoke subclause B of section 67 subsection 1, then he has to say yes, all this you were doing to evade tax. Now supposing they have conducted raid, everything, now you have a right to inspect the file. So once you file an appeal, you want to go to writ petition, inspection of file is a must. As an appellate lawyer, you should make it a habit to inspect the file. Never ever file anything without inspection. For example, I have to file a review in tribunal, I will inspect file of tribunal. I know what I filed. मुझे ये भी देखना है कि ट्रिब्यूनल ने क्या लिखा था उसमें, कौन से नोट्स बनाए थे. जज लिखते हैं ना, मैं सारे आपकी जजमेंट हम लिखते हैं, हमने कोर्ट हमारे नोट्स बनाते हैं, फाइल में तो कुछ है ही नहीं, क्या कौन से नोट्स बनाए थे आपने. So whenever you have to file an appeal or a petition or seek relief, if there is a file where your file documents or some adjudication has taken place, you must go and inspect the file officially. Take copies. You have all the right to take copies. There is nothing confidential in this. Your own case. So A और B में दोनों में फर्क है. A में taxable person हो, is supplying of goods or services, whereas subclause B doesn't deal with the supply of goods. It only says storing the goods in a warehouse, godown or transporter. तो दोनों में बहुत मटेरियल डिफरेंसेस हैं, दोनों को जजमेंट्स अलग अलग हैं. नाउ
recently we had a notification regarding the implementation of GST on the pre-packaged which were exempted earlier. Now after the implementation date of this notification, 4-5 days later, a lot of GST authorities moved to Old Delhi's a lot of warehouses. The people who are into dealing into this articles which were initially exempt, and in their godowns, warehouses, they found that still the 25 kg packaging was available. Penalties, they wanted to impose penalties on them, and even after the due date, you are selling these things. Then the associations came forward and gave a representation to our honorable finance minister also that right now you have done this kind of changes without a prima facie discussion with our RWS, and we don't have that timelines to change the packaging, and we are sitting on almost on 10 to 15 lakh empty packets. What do we do with that? And that is also a cost. So they have added 1 kg extra layer, which is out of the ambit of the Legal Metrology Act, which prescribes the 25 kg packing, and based on the special approval which was given by FM2 for some particular days, I think around 40-50 days, till the time we can have a new packaging of 30 kg or whatever they decide is allowed. Now in this, the authorities coming to them and rate them or check on them, is it legally valid or
no? FM is nobody. She is nobody. She cannot overrule parliament. Who the hell is she? She is nobody.
But they have given
This-
relaxation.
If you see a case of Nestle India, it's a Punjab case, where at the stage of assembly, milk, a particular milk was allowed to be tax-free. Assembly, not general statement. Assembly में उस पर debate हुआ. Nestle India versus State of Punjab, this is the case. Exemption नहीं हुआ. Based on the assurance in assembly, which was widely publicized, certain Nestle India sold this material. They went to Supreme Court. Supreme Court distinguished between the powers of a minister and power of assembly. अगर ये पार्लियामेंट में हुआ होता तो वैलिड था, और कल को तो हमारा मनीष सिसोदिया बोल देगा सारा टैक्स फ्री हो गया, वो भी तो स्टेट जीएसटी का फाइनेंस मिनिस्टर है. कैन ही से सो? द फंक्शन ऑफ जीएसटी काउंसिल, that is the role of GST council in GST law. Everything has to go through them. Madam Nirmala Sitharaman is just nobody for this purpose. Tax will be levied, let them go to court now. She should have told GST council to consider issue notification. वो वोटों के लिए जिन्होंने खुश करने, आप कुछ भी बोल दो. मोदी साहब भी बोलते थे सीमलेस इनपुट टैक्स क्रेडिट होगा, तो मिला आपको? कैन यू एनफोर्स दिस अगेंस्ट प्राइम मिनिस्टर? आंसर इज नो. अभी जो सुप्रीम कोर्ट में चल रहा है फ्री बीज वाला, वो कहते हैं ये तो वोट बैंक है, फ्री भी देनी पड़ती है. चीफ जस्टिस कहते हैं नो. सो व्हाटएवर, when there is a mandate of law, you have raised a good point. When there is a mandate of law, you can be tax exempted schedule 1, 2, 3, 4, 5. आपको उनमें आना है, आपको एडमिनिस्ट्रेटिव रिलीफ देना है, इशू है सर्कुलर इशू कर दो. आप इशू कर दो, स्टेट वाले मानेंगे नहीं, बोलेंगे टैक्स तो. एसोसिएशन खुश, वकील ने पैसे ले लिया ड्राफ्ट करने के, और एफएम फोटो खिंचा ली, फोटो दीवार पे लगा दी, जीरो. नाउ
नोटिफिकेशन आया दैट हैज स्टार्टेड एक्सेप्टिंग चेकबुक्स. बैंक से भी चार्ज शुरू कर दिया आपको चेकबुक्स के. बट मैडम सीतारमन ने पार्लियामेंट में बोला है कि चेकबुक्स व्हाट इट मेंट वाज कि जो चेकबुक बैंक को बेची जा रही है, तो बैंक आपको दे रहा है, उस पर जीएसटी नहीं लगाना. बट ऐसा नहीं लिखा हुआ तो है नहीं.
there is a difference. This is a statement made by finance minister, not discussed in parliament. नेस्ले के केस में असेंबली ने अप्रूव कर दिया तो नोटिफिकेशन नहीं हुआ था. ये तो बहुत जजमेंट है कि एफएम इंटरप्रिटेशन है, नो मीनिंग. नो टैक्स लॉस, नो मीनिंग. कल को मैं टैक्स लगाता हूं, आप क्या बोलेंगे? एफएम की स्पीच जाएंगे उठा के, यही करेंगे, और तो कुछ है नहीं आपके पास, तो विल कैन कोर्ट एग्री? whether statement amount to waiver or liability? The answer is no. If a particular thing has to be done in a particular manner, it must be done in that manner or never done. That is Amrit Food Union of India. ये सुप्रीम कोर्ट की 4 लाइन का रेशियो उस केस का. कल को हमारे यहाँ कमिश्नर आके बोलते दीपक कुमार, नहीं जी मैं आपको इंटरेस्ट सारा छोड़ दूंगा, कोविड था ये था, कैन ही लीव? नो. जो इन्होंने डिमांड नोट कोविड में असेसमेंट टाइम पे नहीं की, even when their Maharashtra was a circular, Bombay High Court quashed all the demands, assessment order expertise, time barred. कमिश्नर का सर्कुलर था, कोविड के कारण हम ये कर सकते हैं, वो कर सकते हैं, based on Supreme Court judgment. Bombay Court said no. High Court did not enlarge the time for assessments. It was only of filing of petitions, appeals and other things, not for assessments. आपकी डिफॉल्ट बेल मिलनी थी, चार्जशीट फाइल नहीं की किसी ने, ये सुप्रीम कोर्ट के जजमेंट के बाद ही आई थी. कहते वो कोविड था तो जो हमारे थे चार्जशीट, कहते नो, डिफॉल्ट बेल इज द राइट. सारे में नहीं की, बेल इज ऑटोमेटिक. So these interpretations, there are n number of Supreme Court judgments on this issue, and FM view has no meaning. It should be discussed in Parliament or State Assembly, appropriate legislature, debated. Only if notification doesn't come, you can take benefit. अब कई states ने जो industry benefits से देने शुरू किए, they were High Court reversed everything. You give from your funds, refund दो उनको, आपकी प्रॉब्लम है. Now you cannot say कि मेरी सप्लाई एग्जाम्प्ट होगी. फॉर एग्जाम्पल हिमाचल में सारी वो बद्दी बुद्धि से होता था, it's all out, pay GST. हिमाचल गवर्नमेंट इज गिविंग देम रिफंड. वो जीएसटी रिटर्न देते हैं, पैसा वापस लेते हैं. ये नहीं करेंगे वो सप्लाई पे जीरो को हमारा पे नोटिफिकेशन था. Unless those notifications were adopted in GST Act, they have no force at all anymore. That act is repealed. और उन चीजों को इसमें सेक्शन 176 में सेव नहीं किया गया. रिपील सेविंग सेव करते पता बनता था. अब ऐसे में क्या, वो क्या बोलती है एफएम, वोट नहीं लेने, चंदा भी लेना, वोट भी लेने. हाँ भाई हम कर देंगे, तो करो ना, सर्कुलर इशू कर दो. हालांकि इस केस में सर्कुलर इशू नहीं हो सकता. You cannot change laws, tax law by circular. It has to be notification. Anyway, so you have to know the difference between 67 subsection 1A subclause A and B. डिपार्टमेंट के ऊपर। हाँ, तो आप उसको बोलो जी हम तो शेड्यूल 1 में डील करते हैं, हम हमको टैक्सेबल गुड भेजते ही नहीं। और आपका कहो जी अनरजिस्टर्ड हो, हाँ उसको लिख दो जी, मैंने तो 1 हफ्ते पहले धंधा शुरू किया है, मेरे तो अभी 1 लाख की सेल नहीं है, मेरा क्या करना है आपने। हाँ इन्फैक्ट कर सकते हैं, क्यों नहीं कर सकते, तुम्हारे कहने सोना मेरा छोड़ देगा आपको। वो कल को आपने अंदर 1 करोड़ का स्टॉक छुपा के रखा हो फिर। सो 67(1)(a)(b we would examine in detail only these two sections, बाकी नहीं। 67(6) टच करेंगे, 67(1) करेंगे, बाकी प्रोसीजरल है, उसका कोई लेना देना नहीं। हाउ डू यू गेट रिलीज ऑफ गुड्स, देन वी टच इज 68 and 69, we have done it, but again touch it the rest part pursuant to search and then link it with section 83 जो आज हमने किया। इसका कल्मिनेशन सेक्शन 83 में होता है, बैंक कोड अटैच होने हैं आपके। सो थैंक यू सो मच। बोलो बोलो।